Hello and welcome back to Fame Under Fire from BBC Sounds with me, Anoushka Mutanda-Dougherty. Just a warning, we're doing an update on the David case today, and as always with this one, some of the details are graphic and some listeners may find them upsetting. But David was back in court for a status conference. Reminder, he is the 21-year-old singer accused of the unlawful dismemberment, murder and continuous sexual abuse of 14-year-old Celeste Rivas Hernandez, whose body was found decomposing in a car linked to him. He has entered a not guilty plea on all the charges. Now, we've done multiple episodes on this. If you're not up to speed, you can go and watch them now, and we'll meet you back here. So we had the status conference and we know that it won't be the last one. It's being pushed back again. We found out that the preliminary hearing is now going to be on the 21st of July. That's where the prosecution lay out all the evidence they claim to have to convince a judge that this case should go to trial. But it is being reported that the prosecution and the defense are going to coordinate witness schedules, which means at that preliminary hearing, we might be hearing from some of the people who testified in front of the grand jury, like David's best friend, Neo. That means this is probably going to turn into a bit of a mini trial. Pushing back the preliminary hearing does, of course, push back any potential trial that could be coming. We haven't had anything from the family on this, but they did previously release a statement through their lawyer who reminded everybody that they, quote, still have bills to pay and jobs they go to every day. All they want is time to grieve and heal. Now, coming up, we have our resident trial attorney, Shaun Kent, answering all your questions on this potential trial and big criminal case questions as well. But first, I'm hearing that some of you have not got your tickets to Crosswires. Why not? They're literally free. We're on at 2:30 on Saturday, the 4th of July at the Cole Brothers venue. We're going to be doing a live recording with behind-the-scenes previews, tidbits, stuff they won't let me say on air. And Shaun Kent is coming from South Carolina to the UK on the 4th of July. On the 250th birthday of the United States of America. He's coming to spend it with the Brits. That's a big deal. Now, if you want to get tickets, visit crosswires.live/fringe for the full list of programs and how to get those free tickets. Get it together. You really, really don't want to miss this one. But right now, I have the man himself joining me. Shaun, we've just been getting an update on the latest developments in the David case. And we're going to talk to you about that. But we've got so many questions and myths to bust about criminal cases in general that have been coming in. And I think people are forgetting the difference between criminal, between civil, between state, between federal. So we've got the expert here to go through them. But before that, what does everybody need to do?
Buy chicken wings. No, did I
Go again. You got this, Grandpa. Come on.
I got this. Everybody needs to go and create a MySpace account. Isn't that what it's called? Call me Grandpa. Everybody.
I wouldn't know what that is, but okay.
I'm coming to London. God save the Queen. Idris Elba.
Shaun, I hate to break it to you, baby, but the Queen is dead.
Oh, God save the princess.
Is this the first you're hearing of it? God save the king.
The Queen is dead? I'm coming to London. I'm looking forward to meeting as many people as we can possibly meet. So please, please, please grab some tickets so we can see and meet and greet and talk. And you guys can teach me about British culture. I've already learned that Kent, London is not a place, which made me very sad.
Yeah, Shaun also seems to think that the festival Crosswires is in London. It's in Sheffield, which are two separate places. But you try and explain that to an American and
it's all one place. I don't understand what you guys are talking about. When
it's only 2 hours to get there.
It's all one place. Switzerland, Norway, London are all in the same town. Right?
Just don't get violent with him when he comes over here. He means well. But thank you for that. Thank you for your video where you repeatedly referred to Sheffield as London. It's okay. We forgive you. We know you're having a hard time in the World Cup, so we'll let you off. Now, one of the biggest questions that I have, and I'm going to be a bit sneaky because I'm going to go in with my first question first, rather than the listeners. But this has been bugging me for a while. With a preliminary hearing where they're open to the press and the public, and they lay out the evidence that they have in order for the judge to make a determination whether this should proceed to trial, how on earth is that not biasing a potential jury pool?
Well, everything can bias a potential jury pool. Everything. And prosecutors are very, very slick. And that's why we always see these press conferences that they insist on doing. And the defense does them too to try to get their message out. But once we choose and select a jury, the judge is required to ask one question and one question only. Even given the information you know, even given everything you've heard, can you personally be fair and impartial? More importantly, they focus on impartial. And if that juror member says, I've heard about it, I know about it, I've read about it, but I can put all that aside and listen to just the evidence that's presented in trial and be impartial. That's the only standard that is required.
Shaun, I'm sorry. I know you love it, but it feels like a really flawed system to me, because how on earth can you listen to 5 days of a preliminary hearing with all the evidence and say, you know what, that didn't sway me an inch either way?
It seems like it, but if lawyers do their job and do their back research and figure out who human beings are, and then we have some things called voir dire, and all that means is we get to ask potential jurors certain questions, and amongst them, you ask things like, are you on social media? Are you a criminal trial junkie? Do you watch certain things? And then as a lawyer, if we learn certain things of information about somebody, even though they say they're being fair and impartial, we can use what are called peremptory strikes to get rid of somebody. We can say, look, judge, that person there, they may say they're being fair and impartial, but we want to use one of our strikes to remove this person because we don't want them on the jury. So it's an exclusion method. It's like a checks and balance to make sure we don't get someone who is biased on the jury.
That's so funny to me, because it's the crime TikTokers and the court junkies who are the ones desperate to be on the juries. And they're probably going to be the first ones to get struck off.
First one.
You have a TikTok where you report on this stuff every damn day, out.
You're not wrong. 100%. If I'm picking a jury and I see that you are a avid social media crime junkie enthusiast, I want you on no part of my jury. I want you gone 100%. And I think prosecutors, both sides, feel that completely. That if you're posting on cases, you think that you're the perfect juror, you are the worst juror humanly possible, and we want you out.
And my other question is, do you have to put all your cards on the table for the preliminary hearing, or can you keep something up your sleeve for the actual trial? Or is everything going to be laid out? This is what we've got.
Everything should be laid out, because remember, we have a discovery system. This is not gotcha. And so what ends up happening is you are required to give everything you have to the defense anyway. A good prosecutor doesn't want to leave out some information so that the judge doesn't find probable cause. So they'll tell it all. They'll put their case. We are going to know the case against David once a preliminary hearing is over, because you're almost required to do it, because you have to give all the evidence to the defense anyway. So why hold anything back? There are no secrets.
We saw in some of those early filings, we've seen what the defense alleged that they have, but we haven't heard anything from the prosecution. But they keep saying what they have will prove that he was not the cause of Celeste Rivas Hernandez's death. So it will be interesting to see what it is that they exactly have then. I still don't understand. This feels like a trial, like a mini trial, no?
It's completely a mini trial. In most circuits and most states, the prosecution has to give up all their information to the defense. The defense does not have to give up all their information to the prosecution. So the defense can leave some of their theories and some of their information for the way that they're going to cross-examine people. They don't have to tell the prosecution everything. So the defense can do trial by gotcha.
But how then does the judge make a determination that the defense and the prosecution have enough evidence to substantiate the case?
It's not the question of if the defense has enough, it's whether or not the prosecution has reached the burden to the court to say, we have enough that David is most likely, or there's a real chance. And let's think about that with preliminary hearing. Let's use that phrase. There's a real chance he probably did it. That's the only standard. The real question to the court is, does the prosecution have probable cause, a realistic belief that David could have done it, and this case should go forward? It has nothing to do with the defense. As a matter of fact, technically, the defense doesn't have to be there to ask questions.
So the defense could come to the preliminary hearing and say nothing?
Absolutely. They could say absolutely nothing. They don't have to put on witnesses. They don't have to ask questions. A lot of times when we do preliminary hearings, our client never testifies, never says anything. Sometimes, Anoushka, when we do preliminary hearings, we tell the client not even to show up. And what we'll do is ask questions of the state, the challenge, that they don't have probable cause or a real reason why they arrested somebody and why this case should go forward.
Well, that kind of leads on well to the next question we got in from a listener, because it sums up the difference between the civil and the criminal procedure. Civil cases, defendants have to be deposed. They have to testify up on the stand. Criminal, you don't hear from them at all if they don't want to. They've asked, is there ever a situation where they can be compelled by the judge, the jury, somebody to speak in the courtroom, to testify?
Nope. Guaranteed by the United States Constitution, you do not have to incriminate yourself. So they cannot make you say anything. You cannot be forced to say anything if you do not want to. Even his own lawyer cannot force a client to get on the stand if they do not want to testify. There's no vehicle in which you can make somebody. It is a bedrock of our trial principle that you are innocent until proven guilty. And the judge even tells the jury, You cannot take into consideration that blank did not testify. You cannot even consider when you go back that the defendant did not testify. And the judge tells the rest of the jury, if somebody says that and considers it, you come back to me and we will change that right away. You can't even take it into consideration.
About a situation like it's alleged in this case, that the prosecution say the crime took place in a closed door setting where Celeste Rivas Hernandez, the victim, is deceased, and the perpetrator, who they allege is David, was the only other person there. So is it not a necessity that they testify, since they were the only person in the room, according to the prosecution's theory?
What a great question.
What a great question.
Well, there are two types of evidence that people need to make sure they understand when looking at trial. The two types of evidence are direct evidence and circumstantial evidence, and the judge will explain this to potential jurors. Let's say direct evidence is what you just talked about, eyewitness testimony. Somebody saying, you know what, I saw him doing this. There is a confession. There is a video. There is DNA. This is direct testimony that somebody did something. Now, there's another type of evidence that has the same evidentiary value of direct evidence. It's called circumstantial evidence. You say, what is circumstantial evidence? Well, it's your common sense. Circumstantial evidence is somebody walks into your office, they've got an umbrella, they've got a jacket on, and they are wet. You look at them and you say, well, it must be raining outside. Well, that's you using circumstantial evidence that it could be raining outside. It doesn't mean that it's raining. It doesn't mean that you saw it was raining. You don't know for a fact and they didn't tell you it was raining. Circumstantial evidence is a chain of facts that makes something more likely that can be utilized. There is no difference between the two. One is not stronger than the other. So the prosecution in this case will be putting forth a circumstantial evidence case utilizing chains of evidence. And that's all the stuff they'll put it together because, of course, they do not know for a fact what happened. They do not have David saying this is what happened. So in almost every trial in America, you get to use circumstantial evidence to prove your case to a jury. You cannot force him to testify.
But the thing that you guys don't like is the hearsay. Judge, that was hearsay all the time. Hearsay.
We do not like hearsay. And what hearsay is an out-of-court statement used to prove the truth of the matter asserted. You're like, what in the world does that mean? All that means is we are big in America on what's called the confrontation clause, meaning if you accuse me of something, I am allowed to face my accuser. You cannot say something nasty about me without me being able to ask and question you why. And so what hearsay, basically the bedrock of it is exactly that. You cannot put somebody on the stand who's going to say, well, you know what? Janie told me that David did it. Well, put Janie on the stand so I can confront her, so I can talk to her. You cannot put third-hand information on because that's not fair to the defendant.
Okay, this one's a bit more anecdotal, but we've had it a few times. How do you deal when the defense team and the prosecution team know each other really well? Maybe you went to law school together and you either beat them or they beat you. Is it ever frosty afterwards, or do you just all go to the pub?
Depends. In some jurisdiction, people do take things very personal, but usually when you got, like we had a trial that, pretty big trial a couple of weeks ago. I am dear friends with the prosecutor. We grew up together. We've tried cases together. We've known each other a long time. He does not take it personal. He does his job. I do my job. At the end of it, we shake our hands and sometimes you do take time like normal human beings to process that somebody might be going to jail for the rest of their life or somebody's not guilty. But 9 times out of 10, you don't take it personal and you work on the next case.
This is a good question to finish on, actually. What on earth do you do if, or, potentially your client gets up on the stand and starts barefaced lying and you know damn well it's a lie? You got to tell him?
I'm not even going to tell you that's a great question, but I love that question more than anything because people get views of attorneys so wrong on the show. We cannot and will not. Now, that is something that no good lawyer will ever do. We will not lie for our clients. Just won't do it. Can't do it. I mean, that is a canon under the eyes of the law that you can't lie. And so you run into the situation that you cannot put a client on the stand to intentionally perjure themselves. Perjury is putting your hand on the Bible under oath and just telling a lie. So what ends up happening, we have to look at your question in a couple of ways. One, if the lawyer knows the client's going to lie, if the lawyer thinks the client's going to lie, and then the client gets on the stand and starts the lie. If the lawyer knows the client's going to lie, he cannot put him on the stand. He just cannot do it. It is impermissible. but the client is the boss. And so if the client comes to you and says, I'm testifying no matter what, and you know they're going to lie, you got two options. One, you can move to be removed from the case, and the judge is going to say, nah, bruh, you took the cash, you're going to represent him. So at that point in time, since we can't suborn perjury, we can't encourage someone to lie, we can't help them lie, we put them on the stand, and the law allows them to do what's called testifying in the narrative. What that means is, I'm not asking you questions, I'm not helping you lie. You get your tail on the stand and you just go at it. You tell the jury whatever you want to hear, and you just let them talk, and you don't help them perjure themselves. The second situation we talked about is what ends up happening is if you just think this guy's not telling the truth. They've always told you one story, but you're like, that's some suspicious, I don't necessarily trust you. Under that situation, you're still required to zealously advocate for them because you do not know for a fact that they're lying. Even though you might be suspicious, you have to take them at their word as what the truth is, even though you don't necessarily believe them because you don't have concrete proof. Yours is the weird situation. What happens if you know the client has told you a lie, you know what the truth is, they get on the stand and they start telling the truth, and then you know for a fact they are lying. Remember, you're not allowed to suborn perjury at all. And two, you're not allowed to tell the court that this guy's lying, because that would be violating attorney-client privilege. So in that unique situation, you would have to require the court to take a break. You're like, Your Honor, at this point in time, we need to take a break. And then you would take a break. You would not tell the court what's going on, but you say, Your Honor, we'd like to put him on, and for the remainder of his testimony, remember the first thing I talked about, we would like him to testify in the narrative. And that signifies to anybody who understands the practice of the law, this mug is about to lie. And this guy doesn't want to follow the line with that. And, over here, we hear people say, well, when you meet with a client, or you see in the movies, don't tell me what happened. Don't tell me the truth, because that way I can put you on the stand.
Yeah.
You always hear that, but good lawyers do the opposite.
Wow. Well, Shaun, thank you very much. And you can hear more of Shaun's brilliant legal analysis, his tidbits, his behind-the-scenes threats to the prosecution in Sheffield at the Crosswires Festival. It's live, so who knows what's going to come out of his mouth? Not me. Not my producer.
Oh, y'all are going to be able to censor me? Let's go. You guys don't have a big enough beep button to stop me. This is the game show. You got me in person? Bring it. We are breaking it. I'm wearing a cowboy hat.
I'm going to assert that First Amendment right if it kills me.
Yeah, cowboy hat and tank top. I'm in.
Come on, guys. The tickets are free. Come to Sheffield. Listen to Shaun perjure himself. Libel 50 people. Threaten 50 others. It's going to be a good time. Thank you, Shaun.
Thank y'all so much for having me. I can't wait to see everybody in person.
That was our resident trial attorney, Shaun Kent from South Carolina. And that's it for this episode of Fame Under Fire from BBC Sounds with me, Anoushka Mutanda-Dougherty. As always, we love answering your questions. Put them in the comments. You can WhatsApp us or you can send them to me on social media. It's Anoushka_MD on Instagram and TikTok. And if you want to support this channel and this podcast, please like, hype, and subscribe so you never miss an episode.